Hi there, I'm Andrew Seidel, the Director of Strategic Response here at the Freedom from Religion Foundation. Welcome to this week's episode of Ask an Atheist.
I'm Elizabeth Cavell, an Associate Counsel here at FFRF.
And I'm Sam Grover, also Associate Counsel here at FFRF.
So this week we are going to discuss the decision that the Supreme Court handed down on Monday, the Masterpiece Cakeshop v. Colorado Civil Rights Commission case. FFRF submitted an amicus brief in that case. Liz was the primary author on that, and we've been watching this case and writing about it for a long time. So if you have questions for us, please comment here on Facebook or email at askanatheist@ffrf.org. And there's been a lot of misinformation out there, so please ask any questions that you have. We've heard a lot of things about a narrow decision and talking about a 7-2 decision. We've heard a lot of misinformation about what was actually going on. So ask anything below and we will try to get to it.
But before we get into the specifics of the case, we want to acknowledge that June is Pride Month, which honors the 1969 Stonewall riots in Manhattan. The Stonewall riots are widely considered to be the tipping point for the gay liberation movement in the United States. And the purpose of Pride Month is to recognize the impact that lesbian, gay, bisexual, and transgender individuals have had on the history of that movement and history generally in this country, locally, nationally, and internationally. Obviously, those LGBTQ rights were front and center in the Masterpiece Cakeshop case, and we don't want anyone to interpret what we're saying about this case and the narrow decision, the narrow impact. We don't want anyone to interpret that as meaning that we're belittling the significance of this case for LGBTQ people.
Right, yeah, no doubt about it. This was a very poor decision. But we're going to break it down. So just a little bit of background on the case in case you've been living under a rock. This case arose out of the state of Colorado. The events that the case is about took place in 2012. So in 2012, back when gay marriage was still not recognized by the state of Colorado before Obergefell, a gay couple that visited a local bakery went in to get a cake or inquire about getting a cake for their same-sex wedding celebration. They were going to be married out of state and have a reception in their home state of Colorado. So they went into the Masterpiece Cakeshop where they had a conversation with this guy, Jack Phillips, the owner of the cake shop. And it was a really quick interaction, apparently, where they sort of inquired and said, hey, we're looking for a wedding cake for our wedding. They're two men, obviously, and the bakery owner said, sorry, I don't do wedding cakes for same-sex weddings. And that was that, and a little bit more conversation ensued after that between the bake shop owner and one of the customers' moms. Basically where the owner just sort of elaborated and kind of doubled down on the idea that he doesn't provide cakes for gay weddings. I'll sell you a birthday cake and I'll sell you other things, but I don't do cakes for gay weddings. So the couple filed a complaint with the Colorado Civil Rights Commission, who found eventually that denying to sell wedding cakes to only same-sex customers was a violation of Colorado's anti-discrimination law. So that was a Colorado commission, an administrative commission's decision. It was appealed by the baker to the Colorado Court of Appeals, another state court, who upheld the decision of the commission. And the Colorado State Supreme Court declined to review that decision, but the United States Supreme Court eventually, after this is years of litigation, decided to review the decision of the Colorado State Courts. And Monday, the court decided in a 7-2 decision authored by Justice Kennedy that,
let's pause right there actually, and let's talk just a little bit first about what the cake shop was arguing first. I think it's important for everybody who might not be so familiar with it to understand exactly what they were arguing in the case. There was kind of two big arguments. Why don't you guys each do one?
Right. Well, they kind of fold into one. So basically the argument was all along that the Colorado anti-discrimination law. The state of Colorado, by enforcing the anti-discrimination law against this baker, saying he has to sell wedding cakes on equal terms to same-sex couples, violates his right to free speech and violates his right to the free exercise of his religion. So I'm maybe not specifically.
No, I think those are the two big ones. I think, and those were the two big questions that the religious right was hoping to get an answer on, or at least hoping to get an answer on one of those questions in this case. They wanted to either for the court to say the bakery has a free speech right to deny making this cake, or a free exercise of religion right to deny serving this couple. Those were the kind of two, that's an oversimplification, I think, but that's the kind of the two basic arguments they were making. Is that fair?
Yeah, I think that's right. And what they got was something slightly different and a lot less straightforward. So the decision, again, was authored by Justice Kennedy, and it did sort of rest on a free exercise analysis, but it was sort of narrowly focused on the process by which the state of Colorado, the Colorado Civil Rights Commission, the process by which they adjudicated this case, and the fact that that process showed some hostility towards the baker's beliefs and his motives for denying service to the couple in this case.
Yeah, in the decision it says the Colorado Civil Rights Commission's consideration of this case was inconsistent with the state's obligation of religious neutrality. And then he went on to say there was religious hostility on the part of the state itself, which that's not what the bakery wanted.
Right. So the bakery doesn't get its big decision saying that it has a religious or free speech right to discriminate in the future. And so at the end of the day, if I'm the attorney for that baker, I'm not going to say, yeah, go forth and continue to make wedding cakes only for straight couples. Now, the baker got on, I think, Fox and Friends the day after the decision and said exactly that he's excited to get back into making wedding cakes and will be presumably providing wedding cakes only for straight couples again. So this issue is probably not over. It's certainly not resolved nationally. And I think the way I read the opinion, the Colorado Commission has a lot of leeway here to decide whether it's going to permit this practice in the future.
Yeah, I think it was a very strange decision in that regard, because the questions that the Supreme Court decided to take the case on, the questions presented, they didn't decide the case on. They decided it on this very strange issue of, well, we have been able to spot some hostility towards the bakery's religion, and therefore the entire process was tainted, and so even if he did discriminate, we're not going to worry about that. It's kind of like he got a get out of jail free card is really what it's like. But it didn't affect the law or give this big sweeping license to discriminate that they were looking for.
Yeah, and Andrew, do you want to talk more about what specifically constituted hostility toward the baker's religion?
I definitely think we should talk about that. There were kind of two things that the justices focused on when they were looking at hostility. And there was a couple comments by the commissioners, and two, there was this troll, a guy named with the last name of Jack, who went around to a few other bakeries and was asking those bakeries to put Bible verses, killed the homosexual Bible verses on cakes, and those bakeries refused. So the court was looking at the decisions in the case involving the troll, and then looking at some of the statements from the commissioners. And we really want the statement that was the biggest issue was from Commissioner Rice, and we'll go ahead and throw that up on the screen. She said, "I would also like to reiterate what we said in the hearing or last meeting. Freedom of religion and from religion has been used to justify all kinds of discrimination throughout history, whether it be slavery, whether it be the Holocaust. We can list hundreds of situations where freedom of religion has been used to justify discrimination. And to me, it is one of the most despicable pieces of rhetoric that people can use to use their religion to hurt others. Now, Kennedy cut the quote off there, but there's actually another sentence that the commissioner spoke right after that, and she said, "So that's just my personal point of view." And even that paragraph, I think you have to really stretch to read that as hostile to religion. Bruce, if you want to throw it back up, I mean, this language it's true, right? The Bible and religion have been used to justify slavery and were used to justify the Holocaust. There's nothing false in that statement. And basically what Kennedy then went on to say was that it's essentially an issue of tone. This tone is inappropriate, and therefore you cannot have given the baker a fair shake in this process. And so we're going to go ahead and overturn the whole thing.
Yeah, I mean, that's pretty much what it boils down to, is that remarks were made by the commission at one point in a multifaceted adjudicative process that involved a lot of independent decision making. Without getting too much in the weeds, the commission is only one part of the adjudicative process. And as Justice Ginsburg pointed out in her dissent, leaving aside the historical, I don't know what she said, but like historical truth of those comments, i.e. they're true, but whether or not, whatever value judgment you place on those comments, it's hard to see how one commissioner's comments, when the Civil Rights Commission as a whole was reviewing, one element of a decision that had already been made independently by an administrative law judge who was not one of those commissioners, and a hearing officer before that who had found probable cause to find that the statute had been violated. And after that commission took action, this whole thing was reviewed de novo, meaning from the start, on its own by the Colorado Court of Appeals. So Justice Ginsburg has a hard time understanding how one commissioner's remarks could infect that entire adjudicative process with bias such that the entire thing is unconstitutional and has to be overturned and invalidated. And I think that's a fair point. This is a pretty remarkable standard in terms of what we've seen, the level, the level of factual information we need to sort of say that the whole government action was hostile or biased, such that the process was unconstitutional. This is really one comment, sort of somewhat out of context, or a few comments, some of them out of context, but also, of one commissioner kind of giving her, quote, personal point of view in a layered adjudicative process.
And I think your point too about where it happened is important, because the commission itself had already decided the case. They had already written their opinion in the case, and the baker had actually already appealed or filed a notice of appeal with the Colorado Court of Appeals on that case. The only thing they were deciding in that hearing where that remark was made was whether or not they should stay, in other words, hold off issuing that decision. And they said they voted unanimously not to do that because we've already done this. We've already decided this 3 different times. Why would we stay this opinion? So I think your point is well taken. It's one commissioner. It's at a time when they've already gone through the process. This is kind of a pro forma vote, and it's a throwaway personal comment almost that happens to be true. And I think maybe you're right also, because the paradigm case for hostility to religion was a case called Lukumi Babalu I versus the city of Hialeah. And in that case, I mean, Sam, we've looked at this many times. The court was very clearly hostile to this Santeria church that wanted to set up. And I pulled a few of the facts just for fun. I mean, the city council actually had an emergency session when that church wanted to open up. And there were 7 councilmen and 1 mayor. And the district court said that it was like a mob atmosphere trying to shut this church down. The president of the city council actually asked, this is a quote, "What can we do to prevent the church from opening?" Other council members cited biblical law saying that, well, the Bible says we can sacrifice animals for food purposes, but not for religious purposes. So we can't let this church have animal sacrifice. And I mean, the police were only enforcing this new law that they passed against this Santeria church. There was very clearly hostility towards this religion. And you compare that with what we have now in the Masterpiece Cakeshop case, where it really looked like Kennedy was stretching to manufacture some sort of hostility that really didn't appear to be there.
Yeah, I think it's truly bizarre that the majority opinion focuses so much in on this truly mild statement as evidence of hostility. It doesn't even seem to me that the parties in the case considered that to be hostile. I mean, they didn't spend a whole lot of time briefing hostility toward religion or the Lukumi standard, and didn't talk about it much in oral argument, if at all. And as a result, I think from a lawyer's perspective, it makes pretty bad law going forward. We're left wondering, where is the line? What comments amount to exemplifying hostility in this way for future cases?
I mean,
Right.
You've brought up two great points in my mind. I mean, one is, I think you can actually read that statement as a religious person saying, I don't want my religion to be used in a way that harms others, not necessarily as denigrating religion generally. And the fact that it wasn't briefed and wasn't argued among the parties is really important. I actually went back and looked at this, and I found that they talked about hostility. So the principals, the bakery, the couple, and then the Colorado Civil Rights Commission talked about hostility in 11 paragraphs and in one footnote of 345 pages of briefing. And I threw in the United States amicus brief in that too. I mean, so you're talking, this was not an issue that they really considered. And it could be wrong. It might not have been hostile. We don't know, because they didn't really fight over this. It didn't go through the process that we normally expect to see before a Supreme Court.
Right. And, I think Sam's point also kind of raises an interesting, just kind of step back question about this opinion, which is, what didn't it do? It didn't, like U.S. Supreme Court opinions are supposed to do, it didn't announce a broad rule of law or refine a body of law. Arguably, it announced an application of Lukumi, the case that Andrew
lowered that bar.
just cited, and sort of it can only be said to have lowered the standard for what constitutes hostility towards religion that would violate the Free Exercise Clause. But it's very, Kennedy really is going out of his way to sort of confine the case to its facts, talk about it as an as-applied sort of decision. The constitutionality, the unconstitutionality was in the process, the specific process in this case. He sort of many times sort of implies like, well, it's for another day, whether, this scenario or that scenario, or, denying this level of a baked good or words or frosting or whatever. It's for another day to decide what other set of facts or circumstances would have been constitutional or unconstitutional under the Free Exercise or the Free Speech Clause. There's all this hinting at the arguments that were raised in terms of what the opinion didn't do. It didn't hold that religious believers have a free exercise right to refuse service in violation of anti-discrimination laws, just as a broad rule. It didn't say that. It didn't not say that. It didn't say that a baker has a free speech right to deny service in this case, or in general to same-sex couples. But it didn't say that baking a cake is speech. It did not say that. So it's that kind of an opinion where it kind of raised more questions than it answered.
That's a good way to put it, I think, for sure.
And just in terms of, it also, Justice Kennedy, of course, went to great pains to sort of trot out his super impressive gay rights legacy and just reaffirm Obergefell as the law of the land, and reaffirm, our commitment as a society to equal dignity for gay people, including in the marketplace. So, it sort of, it nodded to the importance of civil rights statutes and the idea that sexual orientation is reasonably protected by states that's a reasonable exercise of state power, and that there's a balance here. So it did some things that were, I suppose, a relief, but it raised so many more questions and just hinted at so many things that were raised in this case that I think a lot of people were hoping would be resolved one way or the other.
Yeah, and for me, that's kind of, there's two real world consequences of the decision, and one is what you were just talking about, where it muddies the waters. The Supreme Court could have made a very clear decision based on longstanding precedent and said, yeah, your religion doesn't give you a license to discriminate. And yeah, this is a cake, man. It's edible. It's not speech. And sorry, like, you don't get to refuse people on the basis of your claim of speech or religion. And we can get into why the claim of speech was completely ridiculous based on the facts here. And I'm sure we'll get some questions about that, so maybe we can hold that. So that's one thing that I think is really frustrating, because it does what you're saying. It muddies what were kind of clear waters, I think. And the second thing that's frustrating, and you can already see this happening, is that the bigots and the literati are going to take this as a license to go out and do whatever they want to do. They're reading this, because it's being misrepresented in a lot of quarters, as a complete win, and we can go out and we can not serve people of color. There was a South Dakota legislator who said, this is a big win. We don't have to serve black people now. I mean, he retracted that comment and said, I would never suggest something like that, even though he just suggested it. But that was his immediate response in the wake of this. And I think we're going to see more of these cases coming up as a result of that. And they're going to be coming before the Colorado Civil Rights Commission and other state civil rights bodies because of it.
I imagine one of the types of questions that we're going to get is exactly what you and that legislator were talking about, which is this idea that this is a private business, right? And his comment stemmed from this idea that it's a private business and they should be able to serve or deny service to anyone.
Do you want to hear a question on that point?
Yeah, sure.
Answer? Okay, so Chris Knutson asks, I don't quite understand why this is such an issue. It's the private sector. No one else's business what they do or who they sell to. If they're willing to give up business for silly belief systems, then let them. I'm sure another cake shop would be more than happy to have the business.
Yeah, so that's put more like the legislator would have put it, and less how I would have put it. So there's this idea that the free market will fix all, and that's an argument that came up in the 1960s when the majority of these civil rights statutes, the Colorado one predates it but has the same type of language as these civil rights statutes from the 1960s. That argument was raised then and rejected, basically because the free market was not fixing this issue as it applied at the time to people of color in this country. There were wide swaths of the nation where
the American South.
Yeah, specifically, where black people could not travel or have equal access to things like hotels, access to restaurants, and other places of public accommodation, which is the types of places that these civil rights laws now say must serve people equally, whether it be based on race, sexual orientation, creed.
Yeah, I mean, I think that's important. I mean, the market continually failed to provide the solution that we needed. And it was actually legitimately harming citizens of the United States because of that. That's why we have the Civil Rights Act federally, and why we have it in most of the states. There's a few that still don't have one. And I think it is important to note that Kennedy did say these laws are legitimate, and it's legitimate to protect sexual orientation under those laws. That was, I mean, he was
unequivocal.
It was unequivocal, and I think he said it was unremarkable, or a word like that, to describe protecting LGBTQ people. And that's I think a big takeaway and a very important part of the case.
Right. That's a popular theoretical point. That's an economic theory, I suppose, but we know better already. We know that the market will not, kill, extinguish discrimination in the marketplace. That might be what would eventually happen in the Denver metro area, but for large swaths of the U.S. and pockets everywhere, there will be places where gay and lesbian people can't get goods and services, and businesses are thriving while maintaining those discriminatory policies. That's what was happening with race in the 60s, and no amount of letting the marketplace play out its drama would have changed that, because there are places where discrimination is tolerated by the majority of people, and those places are not going to boycott a bakery that doesn't serve gay people, just like the majority of customers weren't boycotting restaurants that didn't serve blacks.
And the flip side of that is true, because there were often areas where restaurants that did serve black people were the ones that were being boycotted, and often under threat from the KKK, for instance. Like, if you go to this restaurant and you're a white person, like, we're going to come after you. I mean, so the market actually didn't just fail; it had the reverse effect than what people are arguing.
Right.
Right. So that's why these laws exist, and what we've learned from the 1960s is that there are people who will fight against these laws using religion as their justification. So we saw that in the 1960s when Maurice Bessinger, who owned a barbecue joint, refused service to a black woman and said that it was his sincerely held religious belief to not serve black people. Mm-hmm. And we've seen the extension of that history on into the 1980s, right, with Bob Jones University, mm-hmm. Evangelical pastor Bob Jones. His university had heard of its code of conduct that you couldn't interracially marry, right?
And live together.
Or cohabitate.
Or cohabitate.
In their dorms and stuff. Yeah.
Right. And, fought all the way to the Supreme Court for the right to discriminate based on race while maintaining its status as a university, public university.
Tax-free.
Tax-free university, yeah. Thank you. And again, was struck down because the Supreme Court said unequivocally, you cannot use religion to violate the rights of others. That's not a justification for violating these civil rights laws.
Yeah, and we actually have another question along this vein. I'm going to read it, and then I'm an atheist, but as someone who owns a business, I think a business owner should have the right to not want to serve someone, whatever their reason, especially if the customer can go somewhere else and it is not life or health threatening. And I think it's really important, and maybe we need to do a little bit better job of saying that that's not an issue in this case, right? Like, that has nothing to do with the Masterpiece Cake Shop case, because what the objection raised in the last two questions is about civil rights laws generally. But whatever your objection to those, it is academic, because those laws are in force and they are valid. There's no doubt about that. The Supreme Court has said this time and time again. So that is not an issue in the Masterpiece Cake Shop case. The only issue is, did this guy violate those laws? And in the case, Kennedy basically said, yeah, he did, but he gets a free pass because they said some mean things about his religious.
Yeah. Also to this point, since that was a little bit broader of a question, I think it's also worth pointing out that when we're talking about civil rights laws that have been enacted to undo the harm of just stigmatizing and stripping the dignity away from people based on their identity, we're talking about refusals of service that are based on status, human status. We're not talking about no shirt, no shoes, no service, mm-hmm. or, you're yelling and cussing, or you're a bunch of loud teenagers, get out of my restaurant. You do as a business owner have all manner of private decision-making authority to make your business what you want it to be, even your place of public accommodation, and not serve people that you don't want to serve based on all kinds of reasons. What we've decided is not tolerable and causes more harm than it's worth for your private authority to run your business as you see fit, is discriminating against people in a way that humiliates them, strips them of their dignity, and tells them, you as a person for who you are, the color of your skin, your sexual orientation, your sex, your religion, because of that, you are not worthy of service here. That is not okay. That is a worthwhile harm to guard against with, government action and government regulation of your business. That doesn't take away your freedom and your rights in terms of who you want to serve for different reasons all over the spectrum. But when we're talking about status, and different states have decided to be more expansive in terms of the statuses that they think are worth protecting, but they're all in this vein of identity and dignity and protecting the personal dignity of customers based on their status, not their behavior, not what they want to order, not what they want to buy that you don't want to sell, or even their behavior in your place of business, but based on who they are.
So can we talk more then about the troll in this case and what distinguishes the status, the sexual orientation status of the couple being denied a wedding cake versus this troll being denied the opportunity to have hateful Bible verses put on a cake?
Let us have it.
All right, so the difference, and Ginsburg brings this out in her dissenting opinion, is that if you change the sexual orientation of the couple getting married, make them a straight couple, that changes whether or not the baker would provide them with a wedding cake, right? So their request is about, their request for a cake was denied because of their sexual orientation. On the flip side, these hateful Bible verses were denied by 3 different bakeries, not because of the guy's religious status, but because of the messages that he wanted put on the cakes, right? You change his religion, you make him an atheist asking for hateful Bible verses on the cake, those 3 bakeries are still going to deny him service.
And I think that's the best hypothetical that explains the difference there. You change his religion and the bakeries would still have refused him
right.
Those particular cakes. Which, again, and I think this is important too, we have a couple questions on it here. We have to remember that there was no, in the Masterpiece Cakeshop case, there was no colorable free speech argument because the couple and the baker never talked about what kind of message was going to go on that cake. This was agreed upon in the stipulated facts in the case. They did not even get a chance, the couple did not even get a chance to discuss with the baker what type of message would have been on the cake. They just said, we're a gay couple and we want a wedding cake. He said, I don't do that. The only piece of information he had was that they were gay and this was a wedding cake. He didn't know what they wanted. For all he knew, it could have been just a plain white cake. It could have been a rainbow cake with 2 guys on top. He had no idea. There was no custom message requested or denied or at issue in this case. So the idea that this is somehow free speech then is, to me, just, I'll use the word that the Colorado Court of Appeals used and call it specious. It's just there is no argument to be made there.
Right.
Yeah, I mean, and Kennedy acknowledged this, accepted that it was a stipulated fact that the baker and the customers did not discuss in any way the cake that was envisioned, design or any type of actual speech. But at the same time, Kennedy also sort of was willing to accept the idea that the guy who shopped around all the, anti-gay marriage cakes, his treatment by the Colorado Civil Rights Commission, and their deference to those bakers' conscience-based, refusals to make those cakes, that the discrepancy between his treatment and this, hostile rhetoric or hostile statements by the commission in the case of Masterpiece, Kennedy was buying into the idea that that showed a little bit of differential treatment, and that feeds into the hostility theory that I'm developing, just, I guess, as something to bolster those incredibly weak comments that weren't hostile at all. So those things were sort of taken together to sort of suggest that there was some subtle, his words, hostility towards a religion. And so Kennedy didn't necessarily buy the distinction that was made by the Colorado courts and the dissent and the concurring liberal justices, that it's very different to refuse to provide a specific, refuse to sell a specific item with a specific message. Kennedy was more accepting of the idea that they were sort of in a similar situation as the Masterpiece customers.
So we have a question that's kind of direct on this issue that we've just been touching on from Jeff Richardson. He says, as an atheist, should I have a right to refuse service to religious people? So the answer to that is no. No.
Not based on their religion.
Not based on their religion. Religion is a protected class. You don't get to say, nope, you are a Jew, we are not going to serve you. Nope, you are a Christian, we're not going to serve you. If it's because they don't have shirt or shoes on, they don't meet the dress code, that's a different story. But no, you don't have that right if you're a owner of a public place of public accommodation. We also have another question from Stephen Lowe. Hi, Stephen. Lifetime member, I believe. What case is in the pipeline with the probability to successfully and actually get the court to address the question about using religion to discriminate against gay customers? And is FFRF preparing any briefs on these similar cases?
Yeah, so there is a case in the pipeline right now that one of these Christian rights organizations has been litigating for a long time with an eye toward getting it to the Supreme Court. And it's another cake case. This one, I don't actually remember what state
Sweet
it's in.
Cakes by Melissa
Oregon?
from Oregon.
That's the one,
Yeah.
Oregon. Yeah, and they are, again, refusing to sell wedding cakes to gay couples. And they're currently asking the state's Supreme Court to review the case because the Court of Appeals says that they have to follow the civil rights laws.
And there's another case that the Supreme Court the U.S. Supreme Court has on their calendar for tomorrow. They're going to decide whether to accept cert maybe tomorrow, and that's the florist case. Baronelle Stutzman, I think her name is, Flowers by Arlene's Flowers case, which is a florist. And does a florist have a free speech right or a religious free exercise right to not serve a gay couple for their wedding? So that's also a possibility. And yes, FFRF will be certainly submitting briefs in any of the cases that come up.
And what's really remarkable is even though the Supreme Court just ruled on this exact same issue, I see no guidance in terms of how either of those cases would come down, if taken up by the Supreme Court and decided tomorrow, or what the Colorado Court of Appeal or the Colorado Supreme Court should do in light of Masterpiece with the Oregon case, other than kind of comb the record for comments by the adjudicators and the government actors to see if there's any hostility or, criticism of the beliefs or the motivations of the business owners. Other than that, I don't see any guidance there.
I mean, I know of some guidance. How about past Supreme Court precedent that doesn't apply specifically to rejecting gay customers, but has said over and over since 1878 in the Reynolds case that you cannot use religion to weasel out of generally applicable laws.
Yeah.
Right, which Kennedy reiterated in his opinion, and with a string cite to Piggy Park, the barbecue owner who discriminated on the basis of race, justified it as based on his sincerely held religious belief. That was rejected by the U.S. Supreme Court long ago.
It was laughed off. They barely addressed it. It was in that decision. They laughed it off.
Mm-hmm.
Right, and Kennedy said in his opinion as a principle of law that religion is not a basis on which someone can ignore a neutral, generally applicable law, cited those cases that stand for that principle. So that is good law. I mean, Justice Kennedy at least doesn't see that as a conflict with the Masterpiece Cakeshop case. So you're right. I mean, we're back where we started, except a little bit more confused.
So Colin McNamara, who is in this building, one floor down and is a legal fellow here, asks, do you see any potential benefits to this new hostility standard for we non-believers?
Well, yeah. So one thing is that the reality in this country, where 70% of citizens are Christian, is that the Christian majority rarely, if ever, is hostile to the Christian majority. They are much more likely, more apt to be hostile toward religious minorities and the non-religious. We see hostile comments, actually legitimately hostile comments, from legislators and local commissioners all the time when they're passing laws or deciding specific disputes. And so, yeah, if the bar is truly this low now, that just by saying, well, historically religion has justified some pretty bad things, if that is hostility, then the comments where they say that, godless atheists are coming for your children and they're gonna, destroy our way of life, like, that's hostility in the extreme then.
We've also had real hostility where it's a lot of our cases we get protective orders because there are threats of violence against our plaintiffs, including from government officials. I had a mayor once talking about who they wish they knew who the person was so they could punch him in the face. That seems a lot more hostile to me. And another area where I think we're actually going to see something in the next, probably by the end of the month, is in the Trump 3.0 travel ban case. This is a case that involves banning immigrants from Muslim-majority countries, and we have Trump on the campaign trail with a lot of comments that are very hostile towards religious minorities. And one of the questions has been, are those comments can we use those comments to determine the mindset and whether or not this is genuine hostility towards a religious group?
Are they relevant?
And this case says, yeah, they are. I mean, the bar here is now way lower than the tweets and comments that Trump made in the travel ban case. And there are some legal commentators out there and scholars who are looking at this and seeing, wow, this is a very strange 7-2 split with Breyer and Kagan joining in on this opinion, and thinking that it's sort of a 3D chess game, and they're trying to get a 5-4 decision against the travel ban by joining this weird middle of the road, not giving the religious right what they wanted decision, but letting the baker off the hook so that they can decide this other case in a new way.
Yeah.
Which it's a possibility. We'll find out by the end of the month, probably.
It's a possibility.
People are skeptical.
Legal footnote to that comment is that the travel ban case was brought on Establishment Clause grounds, not Free Exercise Clause grounds, which is sort of where this hostility standard fits within the First Amendment jurisprudence. So it would have to be sort of an expansion of that into Establishment Clause law.
Which would be okay. I mean, and I think another thing, well, we can get it. Why don't we we're okay on time. We have one more question about the gay pride parade case, which I want to get into, but then I think maybe we'll wrap it up with kind of our comments, your final thoughts. So Corey Holcomb asks, does the Hurley v. Irish American Gay, Lesbian, Bisexual Group of Boston, this is a 1995 case, hold any legal precedent that the courts could rule in favor of the baker?
Okay, so quick background is this was a case where I believe it was the city of Boston, the state of Massachusetts has an anti-discrimination law similar to the one in the case of Colorado, but in the context of not a private business, but a private parade, a St. Patrick's Day parade, is that right?
I think so.
A private parade who, they include different people that can walk and do floats and, groups. They were unwilling to include an LGBT group in their St. Patty's Day parade because, and this was a free speech argument, basically that they had a free speech right not to include a group in their parade that professed ideas with which the organizing group, probably some Catholic group that's doing a St. Patty's Day parade, I don't know, I think
that's right.
the private parade organizers didn't agree with the LGBT group's ideas. They didn't want them in their parade. The state of Massachusetts civil rights law was applied to invalidate that and basically say that the parade organizers could not refuse on the basis of sexual orientation some group in their parade. And that was overturned by the U.S. Supreme Court, but on the basis that a parade is a very unique thing, that that would be very odd to apply a civil rights law, an anti-discrimination law to. That it is just, it's a uniquely speech-infused activity, that it's literally an expressive thing. A parade is literally an expression of an idea or a concept, and so
it's not that different from a protest. You're marching for
right.
An idea, in this case, St. Patrick's.
Right. It's expressive activity and or speech in a more pure sense, and so the civil rights statute was sort of wrongly applied against private parade organizers. That it was just sort of a bizarre application of civil rights statutes because it really was a pure speech right that was implicated of this private organization to engage in whatever type of parade they wanted and control the ideas that were being expressed in the parade.
Yeah, and it doesn't take a legal scholar to see the difference between a parade and a cake in terms of who's speaking a message, right? In a parade, everyone assumes that it's the organizers of that parade and the participants who are delivering the message. But if you have a cake, I don't assume that, the message on that cake is the cake baker's message. I assume
that there is a message necessarily.
Well, all right. No, if there are literal words on a cake, assuming
Right.
a cake does deliver a message, like,
Which is an assumption.
happy birthday, Sam, I don't assume the cake baker is wishing me happy birthday. I assume that the person who bought the cake is wishing me a happy birthday, right? So the cake baker's speech isn't at issue there.
Yeah, and again, to get back to the facts and to the questioner, there was no request for a message in the Masterpiece Cake Shop case.
Right.
It was a request for a wedding cake. That's it. And we didn't get into Gorsuch and Thomas's ridiculous opinions, but I think that's okay. They're ridiculous opinions, and don't bother reading them.
Yeah, well, I mean, they see the difference between. They say, oh, it's not a wedding cake that they're requesting. It's a gay wedding cake. Because it's for a
Right.
gay wedding, it's a different item. When literally the cake would serve the same purpose. The same cake could be used in a gay or straight wedding. It's just a wedding cake.
Yeah, 9 out of 10 cakes, if we did a lineup, could be for either wedding, and you would never know the difference. You couldn't pick out whether it was for a gay wedding. or
Yeah,
a straight
Gorsuch
wedding.
is buying the difference between, selling a wedding cake. He's buying the idea that it's okay to refuse to sell a gay wedding cake because you'd refuse to sell the gay wedding cake to a straight customer or a gay customer. That it doesn't matter the sexual orientation of the customer, it matters what the wedding cake is being used for. That's creative.
That's creative, but the implications for civil rights laws generally are massive if that's the standard.
Yeah.
Right?
And thankfully it's not.
Yeah.
So,
And then Thomas just likes the speech argument. He's buying the whole this is a free speech issue at odds with civil rights laws.
So I think we have one more question coming in, and then if you guys want to we'll just kind of do our final thoughts on the case, unless you want to get into Gorsuch and Thomas more.
I think we've covered
No,
that
I want to get
enough.
into Gorsuch and Thomas less.
Okay, and it turns out we're out of questions, I'm being told. So,
Oh.
So you want to do your final thoughts?
Yeah, sure. My final thoughts are that what the cake baker's trying to do in this case is nothing new. It's a new application of an argument that, like I said, dates back to the 1800s, where people are trying to radically redefine what it means to have religious liberty. They're trying to convert it from a shield to protect private beliefs into a sword to attack the civil rights of other people.
Weaponizing religious freedom.
Exactly, yeah. And it has never been the case in this country that religion can be used to justify actions that violate the law, right? The government can regulate actions but not beliefs. That's always been the line. That's the only real bright line that we can have here. As soon as you allow people to act based on their beliefs, they become, as the Supreme Court said in 1878, they become a law unto themselves, and government can exist only in name at that point.
Yeah, I mean, basically what the Supreme Court was saying there is that if you allow everybody to exempt themselves from civil law based on their religion, we have anarchy. I mean, that was what they were saying in so many words.
Yeah, and just riffing off Sam and kind of reiterating my points from earlier, this opinion did not do that, and it explicitly did not do that, and reiterated those legal principles that Sam just said are enshrined in U.S. law and jurisprudence, and that still is the law of the land. And I think there's a lot of bad in this case, especially in terms of what the confusion that it's sowing with regard to a really important issue. There was not a lack of clarity, and a whole nother Ask an Atheist could be on why the Supreme Court chose to take this case, because it doesn't have to review anything, and it did nothing useful. But there wasn't a lack of clarity about civil rights statutes and where the line is in terms of how civil rights statutes conflict with First Amendment rights. I mean, there's not a whole bunch of litigation on this issue that's going this way and that way. So there wasn't a lack of clarity before, and now things are a little less clear than they were a few weeks ago, I think. And I think another part of the bad is that this is really a blow, I think, to LGBTQ Americans who have made huge gains in terms of civil rights protections. And just being included, having that status included in civil rights laws has been a battle, alongside the battle of marriage equality, and those things go hand in hand, because, equality doesn't really mean that much on the books if you don't have the right to access the things that you need to participate in American life with dignity, and without being told, we don't serve your kind, so you need to go find a gay wedding planner and a gay baker and and so I think there's a lot of bad, but I do think the good is that the principles that we work really hard to protect are still valid, that religion doesn't trump civil law, and that individuals don't have the right to violate civil law just based on their religion. And so maybe non-believers will be making more free exercise arguments now, and that'll be the really good. But I do think this could have been a lot worse for us and for the world. And it was pretty well contained to its facts, even if it wasn't really fair.
Yeah, I mean, I think that is pretty much a good summation of my thoughts too. It was a narrow decision. It did not give the religious right what they wanted. It punted on the important questions, which is frustrating because the court could have really come out strong and reaffirmed these principles that go back to the 1800s, really go back to the founding. But it could have stood on cases that it has issued time and time again, and instead it sort of muddied the waters. But again, it could have been a lot worse, and it wasn't. And in all likelihood, there's going to be another case where there's going to be a day of reckoning where they're going to have to decide this at some point. So that's it for our Ask an Atheist show for today. Next week on Wednesday at noon Central Time, FFRF co-president Dan Barker will be on Ask an Atheist with the director of communications here at FFRF, Amit Paul. And they're going to talk about Dan's recent trip to the International Latin American Free Thought Conference in Arequipa, Peru.
Don't forget to tune in for that conversation and check out some of our other shows, such as Free Thought Matters, on our YouTube channel. And
one other quick item to mention. Our national convention in San Francisco, California is swiftly approaching. It's November 2nd through the 4th, and our speaker lineup is awesome. It includes eminent writer Salman Rushdie, former director of Planned Parenthood Cecile Richards, Mythbusters host Adam Savage, actor John Delancey from Star Trek, ex-Muslims of North America co-founder Sarah Hayter, irreverent actress Julia Sweeney, and stand-up comedian Leanne Lord. And also appearing at the convention will be Ensif Hader, the activist wife of a Saudi freethinker whose persecution and imprisonment have caused global outrage. You can register online today at ffrf.org/outreach/convention.
And as always, if you want to receive FFRF text alerts on your smartphone, if you want to know when the religious right is proposing terrible legislation and want to know what you can do about it, please text FFRF to 52886. Data rates may apply. Again, that's FFRF to 52886. Thanks again for joining us, and we'll see you next week for another episode of FFRF's Ask an Atheist.